SJC-13107 in the matter of an impounded case.
Okay, Attorney Henley.
My name is Taylor Henley, and I represent the appellant child.
Can you talk a little louder? Sorry.
Sure, my apologies.
Yeah.
To what end? That was the question the juvenile court judge mused to himself during the child's hearing on his expungement petitions. What was the point, the judge asked himself, of saddling this incompetent child with lifelong carry entries for cases he could neither understand nor challenge? The answer is that there was no point. And in denying the expungement petitions, as the amicus points out, the judge twice failed this child.
Can I ask you just a simple question? Did the judge have the discretion to arraign?
Yes, the judge did have the discretion to arraign. However, here, the judge, it's my position, didn't think that he had the discretion to arraign. Looking at the transcript, what the judge said is, I'm not going to arraign. I'm not going to postpone the arraignment over the Commonwealth's objection. And so the error here is that the judge didn't think that he had discretion to arraign.
Is that what that means? Or does it just mean, I'm sorry, right here. Is that what that means? Or does it just mean he didn't want to continue it?
I would say that was that what that means, because the judge didn't think he had the authority
But
to.
where did he say, I don't have the authority to continue it?
I would take that as the latter phrase, that over the Commonwealth's objection as the.
Just
important
because it
part
was
here.
over the Commonwealth's objection, you think that means he thought he didn't know he could do it?
Yes, that and
He had to go along with the Commonwealth?
well, that and he didn't do the abate balancing test that's required here. So he didn't consider.
Wait a second. So what is, the statute requires a demonstrable error, right?
Yes,
Okay, so what is the error that you're alleging occurred? The failure to continue in order to have the evaluation, or what is the exact error?
yes, that is the error.
So a failure, in that we assess by an abuse of discretion. So you're saying the judge abused his discretion by failing to continue to have an evaluation.
Yes, that is correct.
Okay, and what is the evidence of that? What are you relying on for saying that there was an abuse of discretion? Because as I read the transcript, there was a discussion back and forth, not only with the supervisor for DCF, but also with the child himself.
Yes, two cases in particular, Abade and Torres.
Yeah, but even in Abade and Torres, there was an arraignment, right? And in Abade, the child had already been determined to be incompetent, and there was an arraignment, and that did not present a problem for the court at all. The question was only the transfer hearing.
Yes, so I would say that the court in Abade and in Torres didn't hold that there was a per se rule that you can always arraign a child who is incompetent, rather that judges should perform a balancing test. And this is a due process balancing test because arraignment does implicate due process concerns. And that balancing test.
Yeah, but before you get to the due process balancing test, don't you have to show evidence that there was reason to believe the child was incompetent? That is, that the Section 15 hearing had to be conducted.
So I don't think that would have been possible here because this was the child's first time at arraignment. So there couldn't have been, we were asking for time to have him evaluated for a competency hearing, but he hadn't had a competency hearing already because this was his first time coming into court. And so instead, what was presented to the judge, and I was the trial attorney, so I presented it, were concerns about my interactions with the child and his not understanding the arraignment, my conversations with the staff from his DCF program, who also raised concerns related to competency. The police report itself, the second police report has a description of the program that my client was at as a place for children in the custody of the Department of Children and Families.
Right, but then the judge engaged in this Q&A with your client where he says, you know, how old are you? I'm 13. Where's your family in Virginia? Roanoke. Have you ever been there? Yes, I have. Where do you live when you're in Massachusetts? Lynn. What do you like in school? I like math and science. What are you doing in math? Just division. And the judge says after that, you know what? I'm not going to postpone this arraignment.
Well, I think
after
the judge-
having gone back and forth and talked to the staff and the child.
Well, I think the judge asks a few more questions, if I remember the transcript correctly. He asks things like, do you know who I am? Do you know what a judge does? Do you know what this is, pointing to his robe? And the child says no to all of those questions.
And so
But
does
that's
that
not-
make him incompetent?
Right. And didn't you just say that this is the child's first appearance? So it wouldn't be necessarily uncommon that a child of that age wouldn't have any idea what the role of the judge was. And so that wouldn't really be indicative of anything, and certainly of competency.
So I'd answer that in two ways. And the first is that generally, as a trial attorney, I explain to my clients what's going to happen at arraignment. And so there would be some familiarity, even if the person had never had an arraignment before, of, the person who sits in the middle of the courtroom is going to be the judge. He's
Right,
gonna
and your
ask
client actually says that, right? So the client, assuming that you told your client that the person in the middle is the judge, he says, the judge asked him, have you ever heard of a judge? Yeah, I have.
Yes, exactly. But of course, I do a little more than just tell them that the judge is in the middle. I would tell them what the judge is going to do and things like that. But to answer your question, Justice George, a little bit further, I think that the key thing here is that we're not asking for a whole evidentiary hearing before arraignment. We're not asking for a ton of process here. It's just that the judge do an abide balancing test of if competency is raised.
Well, counsel, let me follow up on this, because this is one thing love your answer on. Is this discrete to the juvenile court? And I'm asking you that because competency is always, from time to time, it's going to be raised on the adult docket as well. And to the extent that an arraigning judge disagrees with counsel that there's an issue of competency, and then the matter's arraigned, and at some point later on downstream, there's a finding of incompetence, and then the case is dismissed on that basis. Are we going to always now be faced with motions to expunge, saying, hey, judge, you should have had a competency hearing pre-arraignment, and you didn't, and now the case is gone because of competency, so now that raises a demonstrable error under the expungement statute, so here we are with our motion. So are you saying that this is discrete because of that balancing test, or would this apply even on the adult docket?
I do think that this is unique to juvenile court because in juvenile court, continuances of arraignments are pretty common for things like Humberto H, motions to dismiss, Wallace W hearings, judicial diversion, and those things are not permitted generally in district and superior courts. To answer your other question, which I think is a floodgates question essentially, I think it would depend on whether the judge appropriately considered the abide factors. If competency is raised, then the judge has to perform an abide balancing test.
Now,
And
I guess that's my question, is you're saying if competency is raised, you go to abide. As I read abide and Torres, the question is, can you have these pretrial events for somebody who's incompetent?
yes,
It's not, so you have to establish that somebody's incompetent. In fact, I think that's why in your briefing, you say your client was manifestly incompetent.
so then I would say that, the remedy for that is to have a continuance and have the evaluation done. To see-
Anytime competency is raised.
Yes, assuming that the abide balancing test.
So there really isn't a discretion, at least in juvenile court, when counsel says, I think my client may be incompetent. At that point, the juvenile court judge must go and have the client evaluated.
No, I think that they must do the balancing test. And so I don't think that the balancing test will always tip in favor of the child, as I argue it did here. For example, and in Abade and in Torres, the charges were much more serious. There were concerns about dangerousness. There were concerns about flight. But in this case, there were no concerns about any of those. The judge didn't impose a bail. The Commonwealth didn't request a bail. And the Commonwealth didn't move for dangerousness, and any conditions could have been imposed pre-arraignment. So, in this case, what we would say is the error would be that the judge didn't do this balancing test. And the balancing test might not always favor the child, as I mentioned, which leads Justice George, your floodgates question. If this is a child, for example, who's before this court a number of times, or has very serious charges, or there are concerns that require a detention, then the Abade balancing test would probably tilt in the direction of the Commonwealth, because the Commonwealth's interest would be higher. That wasn't the case here. And so the judge should have done that balancing test, and I argue it would have been in favor of just continuing the arraignment. And I do also want to add, before I move into expungement here, that this is not that different than the ordinary course of proceedings in terms of competency evaluations in juvenile court. Generally, competency is raised, whether it's by the judge, the DCF, folks who are present with the child, the parent, the guardian, the attorney. Then a competency evaluation is conducted, whether by the court clinic or by an independent evaluator.
Counsel, can I stop you again? So I'm just going to read to you from Abide. It says, in deciding whether due process permits a pretrial hearing to proceed where the defendant or juvenile is incompetent, and then it goes on to describe the three-prong test.
Yes.
Your reading of that is that in deciding whether due process permits a pretrial hearing, if there's questions raised as to the juvenile's competency, then you do the balancing. So you're reading an if into that language.
Not necessarily. I just think that we didn't know, you can't really know for sure if a child is competent.
Right. So whenever it's raised, assuming that there's no dangerousness asserted by the Commonwealth, you must do the three-prong balancing test.
Yes.
Okay.
I do want to move into expungement briefly here. Expungement is a permanent erasure of a record. It leads to no access by states, no state agency or law enforcement agency. And this is, as you all know, I'm sure, a new created statute. And our position is that the category for which my client sought expungement under 100K A5 for demonstrable error by a court employee applies to the error here, which was legal error by a judge.
But the standard for that is clear and convincing evidence. And are you saying that, again, with all of the things that were just raised about perhaps maybe your interpretation of Abide versus perhaps the judge's understanding of it, that this is rises to the level of clear and convincing evidence?
Yes, because the judge merely had to do the balancing test. The judge should have weighed the factors of the harm to the child of arraigning, and which there's a multitude of consequences coming from arraignment here, including housing issues, DCF, custody issues, employment issues, school issues. Should have weighed that against the Commonwealth's interest, which I would argue here is quite low, given that the Commonwealth was asking for nothing but conditions that should have been ordered prior to arraignment. So yes, I would argue that that is a demonstrable error by a court employee by clear and convincing evidence.
Can I just ask, before you go back to expungement for just a second, does it matter to your analysis that the Commonwealth agreed with you that the arraignment should be postponed? Is that part of your argument that both of you, everyone thought that the arraignment should be postponed except the judge?
No, the Commonwealth objected.
Oh, I'm sorry. I thought you said over the Commonwealth's objection, I'm going to go ahead with the arraignment.
No, I apologize if I misspoke. The judge said, I'm not going to postpone the arraignment over the Commonwealth's objection. The Commonwealth objected, and the judge said, I'm not going to postpone the arraignment because the Commonwealth objected.
Got it.
At least that's my understanding of the transcript. I do want to address best interest as well in this case. Although the judge didn't reach it, looking at the expungement petition, the judge denied based on 100K A, essentially saying that my client didn't meet the criteria, because I think it's important to consider at this point. This was a 13-year-old child in the custody of the Department of Children and Families, facing severe neglect and abuse by caregivers, has a lengthy DCF history, has fetal alcohol syndrome, and corresponding developmental and mental health issues as a result of that. Looking at the charges here, they were based on conduct at a program that was aimed at treating essentially these exact behavioral concerns. The nature of the charges, one of the set of charges involved spraying a fire extinguisher at his program, for example. And the fact that this is going to affect the child's DCF placements and long-term goals for the rest of his life if it's not expunged, for a case that he could not challenge, and for a proceeding that he did not understand, and in fact told the judge he didn't understand. Expungement was in the best interest of justice.
Can I ask you one question, counsel? Do you think that the statute allows the judge, even if he or she does not find one of the triggering elements of section A, let's say, I don't find a demonstrable error by a court employee. Nonetheless, under section B, it is in the best interest of justice to go ahead and expunge this.
No, I don't believe so.
Okay.
My reading of the statute is that you need to fit one of the 100 KA categories first. If there are no further questions, I see that I'm out of time. I will rest on my brief.
Thank you. Okay, Attorney Haran.
Good morning, or yeah, still morning. Please support. My name is Donna-Marie here, an assistant attorney representing the Commonwealth. The motion judge here, Judge Murata, properly exercised his discretion, and I do say he exercised his discretion in denying the defendant's petition or motion for expungement for arraignment and arraigning the juvenile, where the juvenile failed to establish by clear and convincing evidence of a demonstrable error by a court employee, and where sealing of his record under the legislative statutes is the appropriate remedy. I do disagree with my sister. It was clear that Judge Murata during arraignment exercised his discretion in arraigning the juvenile. He engaged in a colloquy between the staff at the group home he was at, ensuring that the juvenile was getting services, individual therapy and group sessions. He then engaged the juvenile in a colloquy. And after observing the juvenile, hearing his answers, looking at his demeanor, he made the decision to arraign the juvenile, and that was within his discretion. And I suggest there was no abuse of discretion. So therefore, under the expungement statute, which I first would argue that a judge's decision, it doesn't fall under demonstrable error by a court employee. But even if it did, I would suggest the juvenile failed to show by clear and convincing evidence that the judge did commit a demonstrable error by arraigning a juvenile who was later determined to be incompetent. And I don't know what
Counsel, let's see your first point. Can you tell me what's your support for that a judge is accepted from the conduct of a court employee?
As I'm sure you're well aware, there is no case law on this exact statute. So I looked to other cases from this court, other statutes, just to show that they've always distinguished between judges and court employees. And so based upon that, the Commonwealth would suggest a clear and reasonable interpretation of the statute would be that judges' decisions don't qualify under that. And looking at the statute, the categories of the statute as a whole, it was clear that the statute was made to address the cases that came down, like Bo and Mo, where the wrong person was arrested or the wrong person was arraigned, or and Avila, as I believe the clerk, made an error in putting the wrong date of birth of the defendant. And I believe the statute was created to address the issues. And as you, Justice Gaziano, in the Weber decision said, the point of this is, does the record accurately reflect the charging decision made by the police and the prosecution? And I would suggest that is the statute is to address when the where the record does not accurately reflect the charging decision by the prosecutor and the police, either by police, a mistake by the police, a mistake by a witness, a mistake by a clerk or a lawyer. So I would suggest that this court, we have appeals court to address errors by judges, and that's the proper way to go. So I would suggest a reasonable interpretation of the statute would be that judges' decisions do not qualify under demonstrable error by court and court employees.
Did you compare other expungement statutes? Because I mean, you acknowledge the court employee issue is unaddressed, but I'm wondering if other expungement statutes use language like error of law, or because you don't normally refer to a judge's error as an error of a court employee, but it sort of erroneous legal interpretation or something. Yeah. Did you compare other expungement statutes and whether they have that kind of language in it?
I don't think they have that kind of language in it. The other statutes talk about different offenses which are available for expungement, and then in the judge's discretion, would they be allowed to expunge the record versus other, and that's why the judge couldn't go under, or the juvenile couldn't go under the regular expungement, because he was charged with an offense which is specifically excluded from expungement, which was assault and battery with a dangerous weapon. I would suggest a reasonable interpretation of the statute would be that, to answer your question, no, I don't see that in any of the other statutes where, and I say traditionally, a judge's decision is not judges do not qualify as court employees, as for the reasons stated in the brief and the examples I set forth in my brief. And I would suggest, even if this court were to interpret, given that there's no direct case on point, that they do qualify, that Judge Marana's decision to not expunge a record was not an error. He did not abuse his discretion.
Can I ask you another question? Your sister argues essentially Commonwealth has no interest in the arraignment of this employee when there is sort of an open question of his competency. Do you want to articulate what that interest is?
Yes, Your Honor. The Commonwealth does have a great interest in looking at the cases, and especially in this court, in a matter of a juvenile, went through the history of when incompetency is raised and the different procedures that can occur, different pretrial hearings that can occur. And if this court said in a matter of juvenile, the Commonwealth has an interest in assuring the juvenile's appearance at trial. And I think that's particularly relevant where there's victims involved in the charges, which there were 3 victims involved in the cases involving this particular juvenile. And also from protecting the public from the juvenile. I also think even though the
Can you tease that out a little bit? So by arraigning the child, again, this is a child in DCF custody.
Yes.
You're increasing the child's likelihood of showing up in court. I'm just trying to get a sense of why that is.
Well, each case is different. Each case is particularized. This particular child was in DCF custody, but I can imagine there are numerous juveniles who are not in DCF custody that are in homes that maybe not the best suitable homes, that are in neglectful homes, that are in not the best situations, that don't have the supervision. As seen by the colloquy, this juvenile was given individual therapy, was in a group home, was receiving a lot of supervision. I can imagine if you have a blanket rule across the board that my sister is proposing, that you can never arraign a juvenile when there's a question of competency, you're going to have certain juveniles that don't have these.
Although to be fair, she did clarify that when these issues of danger to the public are not, or, his physical presence are not at issue, it's not a blanket rule that she's proposing. It's just, in this situation where there's no danger, no question that he will come to whatever's next, that you should, as a matter of discretion, issue the continuance. So I guess, to answer Justice Kafker's question, I'd ask you to answer Justice Kafker's question in light of the facts of this case, because as you know, due process is a fact-specific inquiry.
The fact of this case, with the Commonwealth had an interest, given that there were victims involved in this case, to have the juvenile arraigned so that there is an accurate record of what is occurring, so that the juvenile can then get services he may not otherwise be able to get through court services, such as a court-appointed evaluation. Here, it was a private evaluation that was done on the juvenile, but they could have had a court-appointed psychologist that did the competency evaluation that can occur, and other services that occur there. And that is the Commonwealth's interest in bringing the juvenile to trial when there's victims involved in the case. And when juvenile get arraigned, they can the additional services that the court can impose to help that juvenile, such as a court-appointed evaluation and getting an accurate record of what has transpired in the case. And I think those are the interests the government has that are legitimate interests, compared to when you do the balancing test, as the court has elaborated, particularly in, as I said, a matter of a juvenile from this court, in Abbott A and Torres, that when you're talking about arraignment and bail hearings, the competing interests or the risk of erroneous deprivation is low, given that the need for the juvenile to communicate effectively when setting bail is low, given that the factual and strategic errors are, as this court has recognized, are relatively low at that time when they're the greatest at trial.
But isn't a key strategy whether and what your plea is going to be, and isn't that the whole point of the arraignment?
Quite frankly, Your Honor, at arraignment, everyone pleads not guilty. I've never, quite frankly, seen a
So
defendant.
I guess, yeah, that's
plead
my
guilty
question.
at arraignment.
Do we look at this from, what really happens at arraignment, or from the significance of tendering a plea?
I think you look at, this court has said that at a bail hearing, the strategic risk is low, and that was in a matter of a juvenile from this court. So I would suggest arraignment, which is essentially you're arraigning a juvenile, then a bail hearing would be the same thing. The strategic risk is low because there's not much input that the juvenile has to go into because the juvenile is going to plead not guilty. A bail hearing will be held or a determination of what.
But it sounds like the interest is keep getting this record. But we've also written a lot about how we're trying to avoid records for juveniles, right? So
Misdemeanor cases and cases involving, yes, the 2018, the impetus of that bill was to try to eliminate for low crimes, for misdemeanor crimes, that a juvenile is not put into the system unnecessarily where there can be diversion in that. This juvenile was charged with 3 counts of assault and battery with a dangerous
so is
weapon.
that the interest then that we want? I mean, again, I'm trying to tease out what the Commonwealth's actual interest is, which is, it sounds like creating a record of a serious charge, even if the child is incompetent.
Yes,
Is that what?
and bring in a
And can I
juvenile-
just finish the question?
I'm
Is that,
sorry, Justice Kafker, I didn't
is
realize
that-
you were done.
is that what the interest is? And are you also saying that the judge here did not abuse his discretion because that's what we can discern he was thinking?
I agree that the Commonwealth's interest, again, with the case with the victim, is bringing a juvenile into on a serious assault and battery with a dangerous weapon case is, yes, creating an accurate record, bringing the juvenile to trial, and particularly where there's victims involved. And I suggest that Justice Morata did not abuse his discretion when he arraigned the juvenile, particularly given that there was probable cause. And I'd ask you to look at the Newton N case from this court, where there was, in that case, it was clear that juvenile had great mental psychological issues. Just looking at the very facts of the case, he clearly was having some sort of psychological breakdown during the commissions of these crimes. And in that case, the judge on the juvenile's motion dismissed the charges prior to arraignment, saying that she didn't see how the Commonwealth could establish the juvenile's had the mental state to commit the crimes, and that he was clearly in a quote deranged mental state. And this court reversed, saying so long as the Commonwealth moves for arraignment and there's probable cause to issue the complaint, the juvenile should be arraigned. And I would suggest that's exactly what Justice Morata did. Morata did in this case, where the Commonwealth moved for arraignment and where there was clearly, in the not argued other, sufficient probable cause to issue the complaint. And therefore, Judge Morata properly exercised his discretion after engaging in a colloquy with both the juvenile and the people from the and the workers from the group home in arraigning the juvenile. And then I'd suggest Judge Morata further properly exercise his discretion in denying the defendant's petition for expungement when the juvenile failed to establish by clear and convincing evidence that there was demonstrable error by a court employee.
Can I ask if we agree with you that expungement is off the table? Does the juvenile have an option to seal the record, or?
In 3 years, Your Honor, the juvenile under, and I forget the exact statute, but can move to seal the record. And I would suggest this court in Galvin G, I know that was a 2002 case, but has said that there is a limited number of people that can view juvenile records, and it's a law enforcement, any law enforcement, any court, and appointing authority. And the juvenile in that case was arguing there needs to be more protections. And this court ruled that there was adequate protections. And if there needs to be more protections, that was for the legislature to decide and not this court to decide. So I would suggest under that case that there's clear enough protections for this juvenile so that he won't face any adverse consequences in the future. He can seal his record, which is as the legislature intended in cases such as this juvenile's. And there's, being a juvenile case in itself, there's a bunch of protections in place to protect the juvenile that the legislature has enacted. If there's no further questions, the Commonwealth will rest on its brief.
Okay, thank you.
Thank you.